Mr. Miller, on May the 8th this year, Ways and Means Subcommittee hearing, Representative Crowley asked Lois Lerner if she could, quote, comment briefly on the status of the IRS investigations into these nonprofits, end of quote. Ms. Lerner pointed to Congressman Crowley to a questionnaire on the IRS website. She said nothing about Tika's pending report or the disclosure she made just 2 days later about political targeting. As a result, I think very understandably, Representative Crowley has said that he feels misled and has called for Ms. Lerner's to resign. Do you agree with Representative Crowley that Ms. Lerner gave misleading testimony to Congress?
I don't have any knowledge one way or another on that, sir. I've not watched that.
Has the IRS proposed to discipline Ms. Lerner at all for all or any part she played in the underlying events or testimony before Congress?
At this point, now that the TIGTA report is out, now that all this is coming to light, those discussions are ongoing, and I will not be part of those discussions, obviously, but those discussions will occur.
Thank you, Mr. Chairman.
Thank you, Senator. Senator Nelson, you're next.
Thank you, Mr. Chairman. I want to take a different tack. I'd like to go back how we got into this mess in the first place. And the statute, of course, says these organizations, C4, the net earnings of which are devoted exclusively to charitable, educational, or recreational purposes. And then the rule that came along fleshing out the statute talks about promotion of the social welfare.
I'm reminded of one of my granddaughters, age 4. When she knows she's done something wrong, she just shuts her eyes and says, "You can't see me." Well, we can all see what happened. The problem is no one is taking responsibility other than horrible consumer service and apologies. There's a Kansas saying, never lie unless you have to, and if you don't have a damn good lie, stick to the truth. Seems to me we need some real truth tellers here. And facts are stubborn things, and what we have here is targeted harassment and abuse of conservative groups. We can talk about the statute all day long, but that's what has happened. And as we hear daily from others, many who simply have contributed to the candidate of their choice or stated personal views. I think that's very significant. Nobody likes to be audited, and nobody likes to say they have been audited, especially with what has been going on. So what we have on our hands is abuse, harassment, and the suppression of the First Amendment rights, and nobody owning up to it. Now, the fact of the matter is that the IRS has been operating in a highly politicized manner for at least 3 years. 3 years ago, a top economic advisor to the White House divulged confidential tax information regarding a privately held company in order to make a political point. I asked the IG for tax administration for a response. We never heard back. Never heard back at all. Not late, just didn't hear back. Last year, members of this committee, as Senator Hatch has indicated, hearing a growing number of complaints, asked if individuals or groups were being singled out or targeted in the application process. Here's the letter that you sent to me and other members of the committee. It's the same letter, different names. Might want to look up, you'll see this. It's 10 pages long, single space, about 12 point. At any rate, completely silent on targeting, but full of a detailed analysis of the law. But you knew that targeting was going on. I just don't think you do that. That really befuddles me as to why anybody in a position like you or basically Mr. Shulman would ever do that, just not respond. You also said that the Determinations Office was simply trying to find a more efficient way to process a huge number of exemption applications. Here we have Cincinnati, IRS officials milling about, doing their best, but falling short, foolish actions, need more money, need more lawyers. This may have been foolish, but given what I know about the IRS operates, I find it very hard to believe that the IRS employees were given free rein to set up a BOLO list, be on the lookout list, like law enforcement. There must have been a directive from Washington or something. We need full disclosure of how this has happened. There was a news report quoting an anonymous Cincinnati IRS employee. Now, they've been taking a lot of grief here. And accordingly, this quote was attributed to this anonymous IRS employee. Well, we've had all the problems with this, and we knew that it was wrong. We knew there would be hell to pay. We also knew that when it hits the fan, nobody at the top will take the blame. It'll come right down the slide right to us. Well, I'd like to at least have somebody, Lois Lerner, the lady who doesn't do math but can, plant a question, Sarah Hall Ingram, who's now going to be working for the Affordable Health Care Act office, and that's my next question if we go to another round, is how on earth we do that with 15,000 new employees trying to administer the Affordable Health Care Act with a lot of specific questions. Let's move up to Joseph Grant, who's the Deputy Tax Commissioner. We're not going to hear from him. He retired. Mr. Miller, you've apologized, and then you were leaving. Mr. Shulman, you are 6 months out, so can't remember. Mr. Wilkins, the Chief Counsel of IRS, he is not here, but he probably should be here. And then the Secretary of the Treasury, Jacob Lew. It went right up there. And then finally to Catherine Rumler, who is the White House General Counsel. Do any of these folks, and yourself included, ever say what was going on and take responsibility? I just have not seen that. My follow-up question will be in regard on how on earth can the IRS have proper oversight and management to the implement of the Affordable Health Care Act, given the current situation. Thank you, Mr. Chairman.
Thank you, Senator. Senator Crapo, you're next.
Thank you, Mr. Chairman. There's been a lot of discussion about who knew what and when they knew it. And one of the big questions I have, this is probably for you, Mr. George, is it seems that there is an argument being made that there was no political motivation in these actions. Is that a conclusion that you've reached?
In the review that we conducted thus far, Senator, that is the conclusion that we've reached.
And how do you reach that kind of a conclusion?
In this instance, it was as a result of the interviews that were conducted of the people who were most directly involved in the overall matter. And so you take it one step by another, and we directly inquired as to whether or not there was direction from people in Washington beyond those who were directly related to the determinations unit. And their indications to us, now I have to note, this was not done under oath. This was, and again, an audit and not an investigation. But they did indicate to us that they did not receive direction from people beyond the IRS.
When you say people beyond the IRS, that could be anyone up the chain of the IRS?
It, in theory, could be, but we have no evidence thus far that it was beyond, again, the people in the determinations unit.
So in other words, you have simply the statements of those who were engaging in the conduct saying that they were not politically motivated.
That is correct, sir.
And based on that statements not under oath, you've reached the conclusion that there was no political motivation.
Yeah.
Now, have you reached the conclusion that there was none or that you haven't found it?
It's the latter, that we have not found any, sir.
Because it seems to me that it's almost unbelievable to look at what's happening and then say, well, there's no political motivation here. How could an agency with the power that the Internal Revenue Service has engage in this kind of conduct and it not be politically motivated? I think that most people in the United States have a very quick and intuitive understanding of the reason that these revelations are so concerning to the country. As you look at the Internal Revenue Agency and the Internal Revenue Service, more than perhaps any other agency of government, it has the capacity to be the prosecutor, the judge, the jury, and the executioner in ways that can devastate individuals and families and businesses. And Americans understand that. And to have the investigation reach the conclusion that these kinds of actions were just a statistical anomaly, or that they just all sort of statistically came together at the same time, but that there was no finding of any kind of political motivation, I think is almost beyond belief. Is there any way that you can conduct further investigation and perhaps by putting people under oath, identify where the direction came from? As my colleague Senator Roberts has just indicated, we have continuous denial of responsibility for the policies. Those implementing the policies say apparently it wasn't us, and we are asked as an American people to believe that just out of the ethosphere or something, the notion to target these individuals and entities just coalesced and came together?
Senator, as a result, and this is standard practice, as a result of audits that we conduct, many times there are subsequent investigations. Suffice it to say that this matter is not over as we are concerned in terms of our next actions in this matter, Senator Crable.
So you believe there will be further investigation on this issue?
There will be continued review by us, and if it ultimately leads to an investigation, that may be the case.
All right, thank you.
Thank you, Senator. Senator Enzi.
Thank you, Mr. Chairman. Bill from Cheyenne, Wyoming called my office and said that the administrator was fired, was not the real problem, and was just a fall guy. Now, from the testimony that we heard earlier, there was some disciplinary action taken, but the administrator didn't know about it. Doesn't disciplinary action filter up in these organizations? I got a call from Charles of Pinedale, who had concerns that the churches were being targeted as well, noting that the IRS had requested membership lists of his church. That sounds a little bit above and beyond what ought to be done. But to follow up on what Senator Grassley was saying about Mrs. Lerner's question at the American Bar Association tax section, doesn't the IRS have a policy of not commenting on issues subject to an Inspector General Tax Administration audit prior to the public release of the audit? And if so, why did the IRS feel it was so necessary to make such statements days before the report was publicly released? Why did the IRS not shed light on the issue years ago when it became aware of the inappropriate targeting and the discipline that I referred to? Mr. Miller?
First, if I could correct part of your question, sir, going back to the disciplinary action. I actually took that disciplinary action in May of 2012. Going forward, we do have a practice of not talking about investigations or audits. The audit was done at this point. We thought mistakenly that we should get in front and apologize, and that was and reach out to the Hill in advance of it coming out. And that was wrong. We made a mistake.
Let's look back at the testimony. I thought that you were not aware of the disciplinary action. At any rate, David of Casper, Wyoming, posted on Facebook that he'd like to know why the IRS shared information from Tea Party groups with the liberal media group ProPublica. Does anybody have an answer to that?
So I would recommend, and I don't know whether Mr. George can speak to this, but there were in the media discussions of the release of some data to ProPublica. A referral was made to TIGTA on that out of our offices, and at this point, I think Mr. would have better than I.
Okay, and to follow up a little on what Senator Roberts said, Mr. George, when you commented at the House Ways and Means Committee hearing last week, you believed the actions were inappropriate but not illegal. Would you weigh in on whether you still believe that's the case, or any of the actions that were taken by the IRS employees illegal? And if not, would you please elaborate on why your audit findings do not suggest that there was any illegal activity? Because your group conducted an audit and not an investigation, is it true there could in fact have been illegal activity that your audit did not uncover?
Yes, Senator, two things. One, to address Mr. Miller's point about the matter that you mentioned, the release of taxpayer information could be a violation of Title 26, Section 6103, which does have criminal penalties associated with it. That is something that my organization investigates. We take quite seriously. And if we do find evidence of such activity, we would refer it to prosecutors for criminal prosecution. But I'm otherwise restricted by law from revealing any additional information beyond that. And as it relates to this instant matter, the Restructuring and Reform Act of 1998 certainly provides for the action to be taken if IRS employees are guilty of, again, abusing, misusing, and among a number of other things, taxpayer information. We are charged, again, with reviewing that. We're doing so, and if we determine that something has occurred, we will certainly, again, pass it on either in an administrative environment or if, and again, it seems very unlikely, a criminal environment pursuant to this act itself, RRA 98. The RRA 98 has very few, if any, criminal aspects to it, but there are quite a few administrative actions that can be taken as a result of its violation. But based on that, again, we thus far have not uncovered any actions that we would deem illegal in this instant matter, sir.
Okay, I guess the American public will kind of judge that, but it seems like it's very borderline if it's not illegal. My time's expired.
Thank you, Senator. Sir White.
Thank you, Mr. Chairman. I have several questions for you, Mr. Shulman and Mr. Miller. And for me, the basic proposition is simple. Notwithstanding the troubling and unacceptable conduct of the IRS, the political organizations do not want to be scrutinized by the government. They shouldn't seek privileges like tax-free status and anonymity for their donors. To argue otherwise is to advantage tax cheats to the detriment of law-abiding Americans. That's why my hope is that out of this debate will come clear and enforceable rules that treat all political groups equally. So with respect to questions, Mr. Miller and Mr. Shulman, the lines have blurred between political active groups that disclose their donors, those are the 527s, and those who do not, those are the 501c4s. And it has become apparent that organizations that ought to be 527s are applying for C4 status to avoid disclosure obligations. That means there is an incentive for people to choose their tax status based on whether they want to hide their donors. My view is that's a loophole the Congress ought to close. Given that to be exempt from federal income tax, Section 501c4 of the Code requires nonprofits to operate exclusively as opposed to substantially or primarily for the promotion of social welfare. My question to the two of you, Mr. Shulman and Mr. Miller, why was this problem not corrected? Mr. Shulman.
Senator, could you just clarify the problem?
Yeah, the line's blurred. The lines have blurred between the 527s and the 501c4s, so there's an incentive for people to choose their tax status based on whether they want to hide their donors. I think it's real straightforward. The line's blurred, and you all don't seem to have done anything about it, and I want to know why not.
Well, look, let me state that I think the law in the tax-exempt area is very complex, like the rest of our...
Mr. Shulman, we understand all that. Why didn't you do anything on your watch to correct it?
So let me continue. The Treasury regulations that the IRS staff in Cincinnati was wrestling with in this case are long-standing regulations. I believe they're 40 plus years
50.
Old. And I did see that the Inspector General in his report recommended that Treasury ought to look at the regulations. I heard the chairman say he was going to look at this, and all I can say is that this is a very hard task given to the IRS. To have the IRS, which needs to process 140 million tax returns and get billions of dollars refunds out to people every year, to also have them have this piece of the operation that by the law has to be asking questions about political activities is very difficult. And so from where I sit as a former IRS commissioner, if Congress could help clarify the law, that would be a very helpful thing.
Mr. Miller, same question. What did you do to correct this problem on your watch?
So we have put out some guidance, but not enough. I mean, the issues are several-fold. One is we get 70,000 applications for exemption a year. The number of those that are C4s is much less, but even those have doubled over the last few years. There is no doubt that since 2010, when Citizens United sort of released this wave of cash, that some of that cash headed towards C4 organizations. That's proven out by FEC data and IRS data. That does put pressure on us to take a look. As I had mentioned earlier, 527 organizations can do all the politics they want to do. 501c4 organizations have a limited ability to do politics. When organizations choose Plan B, the 501c4 option, it's our obligation to go in and look hard at whether they meet those requirements or could be a 527 organization. But in fact, we would have to talk, and I'm sure staff will come up and work you through. There are some issues in the law now. You can't convert, or we cannot convert a 501c4 organization into a 527 organization at this point, I don't believe. That's a legal issue.
What troubles me is on your watch, when the lines are blurring on this disclosure issue, as far as I can tell, you all didn't do anything to correct the problem in a meaningful way. And I think that's very regrettable. Now let me ask about one other issue for the future going forward. The IRS and the Inspector General agree on a number of reform proposals, but the IRS does not support one of the most important, and that's developing and making public clear guidance for processing potentially political cases. Now, even the best training doesn't prepare employees to fairly apply ambiguous rules. In the absence of clear guidelines, the country is in effect left to the whims of the bureaucracy. Wouldn't it make sense to have those knowledgeable about political campaigns and campaign finance work with the IRS to develop clear and enforceable guidelines that are really at the intersection of these two areas, campaign finance and tax law? Wouldn't it make sense to get two agencies, particularly the Federal Election Commission and the IRS, working together under congressional and public oversight at this point? Either one of you. Start with you, Mr. Shulman.
Look, it sounds reasonable to me, but I don't direct what the IRS does now, so I can't speak for what the IRS should be doing at this point.
Mr. Miller?
I divide the world into two pieces. Should we do guidance? Absolutely. There's a different sort of issue that was involved in the TIGTA report that we ought to take a look at again anyway, and I agree on that. That was whether there's some sort of guide sheet, some sort of template that we could do to move these cases forward, I believe. And there, the concern of those involved, and I was not, is that these cases are very fact-specific, and that may not be possible. But I do think, given all of this, we ought to work with TIGTA.
My time is up, but they are fact-specific, but the Inspector General is right. We can get more expertise if we start bringing in people who are knowledgeable about election law. This was another failure, in my view, in terms of what the problems are that we're dealing with now. Thank you.
Thanks, Senator. I might say, in response to the question asked by Senator Wyden, why did you do something when you're on notice? Frankly, I did. I'm sure Senator Wyden is not comfortable with your answer. I certainly am not, because I wrote a letter to you, Mr. Shulman, September 28, 2010, asking you to look into this very question that Senator Wyden is raising. Clearly, a Mack truck is being driven through the 501c4 loophole for the reasons that have been discussed here. And I must say, the answer we got back from you, what's the date, February, many months later, basically said, yeah, we share your concern, but kind of looking at it, that's all it says. You were on notice, and you did acknowledge that you're on notice, but nobody did anything about it, and I'm just quite disappointed. Next to Senator Menendez.
Well, thank you, Mr. Chairman. And I join you in your opening statement. The idea that any government agency would use searches of politically charged terms to single out groups for selective review is truly offensive to our concept of democracy.
And I believe it's not only unacceptable, but it's pretty appalling. And it undermines the very nature of a government and its people that consent by virtue of believing that its institutions will work in a way that are fair and transparent. Having said that, I also have real concerns, and I want to follow up on, I think there are two scandals here. One is the management failures and the whole process of singling out specific groups. The other is how we take statutory authority and then extrapolate it differently than what the Congress meant. I read the statute with reference to 501c4s, and it says civil leagues or organizations not organized for profit, but operated exclusively for the promotion of social welfare. The IRS took that statute, the congressional vote, to say exclusively, and turned it, an organization is operated exclusively for the promotion of social welfare if it is primarily engaged in promoting some way the common good and general welfare. I didn't see a vote for primarily, I saw a vote for exclusively, because we wanted to limit the scope of who could avail themselves of the benefit of a 501c4 under the tax code. So do you believe, I'd like to ask the Inspector General, do you believe that a more literal reading of the statutory language could have taken some of the authority of the subjective scrutiny out of the hands of the IRS officials, thus avoiding or mitigating some of the problems that we're talking about here today?
Senator, I will respond directly to your question, but I just have to acknowledge that the Secretary of the Treasury has delegated all tax policy questions exclusively to the Assistant Secretary for Tax Policy. And with that said, the direct issue you raised with me was beyond the scope of this audit. But that said, it would seem as if what you're saying would be accurate, that, that they should have not necessarily taken the interpretation that they did, but I will have to leave it.
Mr. Miller, Mr. Shulman, how do you jump from exclusively to primarily? How do you take the congressional action and then really subvert it to a different view?
So let me say a couple things. One is, as I mentioned, this was a regulation, a Treasury regulation that's been in effect for many years, and so. Really speaking on behalf of myself, and I think I know how long Mr. Miller was there. This was in place when we got there. I don't necessarily disagree with you that this is, as I told Senator Wyden, this is a place that Congress should look, because from where I sit, the IRS is given a very, very, very difficult task of trying to go in and figure out. There's enough you can do some political activity, but you can't do too much. And the confusion and breakdown that you saw happen in the Cincinnati office is inexcusable. But I would also posit, this is my belief, that part of it was because of the very difficult task given to these people.
Well, then it's a task that we should clearly correct if you can't do it. I mean, I envision exclusive to mean exclusive, not primarily. I have a copy of an August 2012 op-ed by Carl Rove, which I asked unanimous consent to be included in the record. In this, Mr. Rove writes, roughly 111 million of Mr. Obama's ad blitz was paid for by his campaign. Outside groups chipped in just over 20 million. The Romney campaign spent only 42 million over the same period in response, with 107.4 million more in ads attacking Mr. Obama's policies or boosting Mr. Romney coming from outside groups, with Crossroads GPS, a group, meaning him, Mr. Rove, I helped found, providing over half. Now, I don't mean to single him out as the only bad actor here, because there are many represented on the entire political spectrum, but this is the nature of the abuse. There is a reason that you seek a 501c4 status, because you can hide your donors, and you also have a tax advantage. Otherwise, you don't need to seek the 501c4 advantage. So the reason that people come forth with this, I'd like to see what does it cost the American taxpayers in the granting of all of these 501c4s when they are not being used for social welfare, but they are being used in essence for political advocacy. Final question to the IG. Mr. Inspector General, did Chairman Issa sent a letter on August 3rd of 2012 to all of the Inspector Generals reminding them that under the Inspector General's Act, it requires IGs to report particularly flagrant problems to Congress
to the agency head within 7 days via what has become known as a 7-day letter. Did you receive that letter? And if so, did you respond to inform Chairman Issa of your investigation into the IRS?
Senator, we did receive the letter, and Chairman Issa's committee was the first to actually contact us regarding this matter. And so through the course of engaging in the review, on occasion, we have had communications with his staff.
In 2012?
And since then, yes.
All right, thank you, Mr. Chairman.
Thank you, Senator. Senator Cardin.
Thank you, Mr. Chairman. And I think we all will agree that we cannot allow, permit, tolerate targeting by political views, and that we need to make sure that the process is clear to hold those accountable who violated that, but also to make sure this doesn't happen again. Having said that, I just want to concur with many of my colleagues on the interpretation of the law. The regulation, Mr. George, that you were relying on was issued in 1958, if I am correct in the year. I know it's been issued a long time ago, where you said not their primary activity, interpreting what is exclusively engaged in promotion of social welfare activities, which seems to be hard to understand. 1958, the political parameters were totally different than they are today. And I understand whose responsibility it is to change regulations, but it seems to me that this is an area that needs to be dealt with. I want to get further clarification on page 8 of your report, where you have a pie chart that lists the 298 cases that were pulled out for additional scrutiny. You identify 72 with the name Tea Party in it, if I'm reading the chart correctly, 11 with 912, and 13 with Patriots, and then 202 others. Can you give us further clarification what makes up those 202?
Senator, we were not in a position to do so because in many instances, we were only reviewing the names of the organizations. And so certain names were so generic that we were unable to determine whether or not they had a particular point of view or what have you, or whether or not the IRS was using the policy positions that those groups held as a determinant for the special handling. But in other instances, when the name Tea Party was used, it was quite obvious, or if the name The Patriot was used, or if 11, 9, 12 rather was used.
What was the standard for the selection of those 202? Were you able to determine that?
That all of the 202 were reviewed to determine whether or not significant campaign intervention was engaged in.
But if I understand correctly, the 90 some were because of the name of the organization.
Correct.
The other 202, why were they selected?
According to our review, it was to determine whether significant campaign intervention had occurred by those organizations.
I understand that, but what basis was used to single out those 202?
I'm going to defer to actually Mr. Miller.
Mr. Miller, do you know what basis was used for that 202?
I don't. What I believe, Senator, is what's in the report, which is while the term Tea Party was used, more cases were being pulled in where folks saw evidence of political activity. They put those cases in. Those would include any case that came across their screening desk, sir.
But you don't know what standard they used to make a judgment that they were involved in political activities. Could have been the name of the organization. It could have been, I'm trying to figure out how these were selected. There has to be some rational, or at least some stated reason, unless it's a random selection. Is it a random selection?
No, sir. I believe there was evidence of political activity that the screener believed was there, and therefore it was put in. I'll say this: it is my hope that when you all do your review, that some of these things will become more clear than they are in the report.
Well, I appreciate that. I'd be very interested as to how the IRS went about selecting all of the groups for review, in addition to the ones that were selected because of the use of the word Tea Party or 912 or Patriot, which is absolutely wrong.
But Senator, if I may, sir, that is part of the problem, because in many instances, there was no indication at all in the case file why these particular cases were selected. And that was something that we identified as a problem in the way the IRS handled these matters.
And Mr. Miller, you don't know the standards that were used
I only
in
know
terms of political activity.
I know what has been in the report, and I believe what was in the report, what's indicated is that the screeners were looking for evidence of political activity.
I think we need to have more information as to how these were selected. If there was an arbitrary selection of 90-some, it could well be there was an arbitrary selection of 300. And I think we need to know how that was determined. One last question, and that deals with your training dollars. One of the Inspector General's findings is that the staff was not adequately trained in order to meet the challenges. This is a complicated area. It involves some tough judgments, but it has to be done in some uniform way. Can you just share with us whether you have adequate resources in order to pursue the training at the IRS? Senator Portman and I, a few years back, worked on IRS reform. And I think both of us hoped that we would never be at a hearing like this after the reforms that were passed back then. One of our objectives was to make sure that that IRS was handled in a professional, nonpartisan way and had the resources it needed. Do you have the resources you need to have properly trained staff?
So first I'll say we did not train here well enough. There's no question about that. I think that's a finding of the IG report, and we believe that's the case as well. More generally, we are down $1 billion over the last couple of years, the IRS is, and that's caused us to cut training fairly drastically. We have in this area, we have maybe 140 of our folks that do this sort of work, both in Cincinnati and reporting to Cincinnati through some other offices, which has been somewhat of a confusion I've seen out there. But we have 70,000 applications that come through. Do we have the resources to get the job done? I don't believe that we do at this point.
Thank you very much. Senator Brown. You're next.
Thank you, Mr. Chairman. I thank you to the witnesses, and I agree with everyone here that's made this statement with some tone of anger in many cases that IRS should never go after anyone, should never single out anyone because of their political philosophy or their political affiliation, period. That's the most important thing. It is, however, I believe, not worthy of public trust to maintain the current troubles or the result of the entire fault of freelancing low-level employees, or they're asleep at the switch managers. It's pretty clear that it comes from a leadership vacuum that's persisted for too long, far too long in this particular area of tax law. The failure of the IRS for 5 decades to define what constitutes political activity. You know the statute. It's clear that 501c4s, available organizations that are operated, quote, exclusively for the promotion of social welfare. Back in 1959, and since we've not seen change to that. The gray area that exists today was created by the Treasury when they issued regulations and defined an organization operating exclusively as an organization primarily engaged in promoting social welfare. So explain that to me. I know you've talked about that in this hearing already, but what does the term primarily for social welfare mean? The IRS has not made that clear when the statute says exclusively, and that's really at the root of so many of these problems, Mr. Miller.
So I think, Senator, that you've mentioned this, and we've talked about this. We've had 50 years of this regulation in place. Organizations are operating within this framework. It is only recently with the flow of political dollars that has been called into question about whether this is the appropriate way to regulate these organizations. We have not made a good job, I think, of putting out guidance on even how to figure out what primarily means. Yes, you look at the activities of the organization. Yes, you look at the dollars of the organizations and the expenses of the organizations. But we've not been crisp on that either, and that's what our folks were faced with as well. So
no, the issue is how long do we wait? I mean, much of that is your predecessors, but we've had 3 years since Citizens United. We have 2 federal elections, tens of millions of dollars, state after state after state has been spent by 501c4s. How long do we wait until the IRS from Washington, not blaming it on Cincinnati, but from Washington, how long do we wait?
That's a question that you'll have to ask my successor, sir.
Mr. Schulman, let me ask you, what if any state steps were taken to define a test for primarily promoting social welfare? Where's that line? Were steps taken to establish a clearer definition of political activity?
I think the Inspector General stated this, that the Treasury Assistant Secretary for Tax Policy has authority to make tax policy. I actually don't think it's fair to blame the IRS for not fixing that. I think the IRS can give input, but this is actually something that if Congress decides it should be changed, Congress should either clarify or it should be done in regulation.
All right, thank you. Thanks, Mr. Chairman.
Sanderson?
Thank you, Mr. Chairman. I think it's clear that there are liberal groups and conservative groups that both follow the law, follow the regulations as they exist today. But there was only one group that was targeted. And you all can get here and say that there wasn't political targeting, but it just doesn't comport with the facts. Maybe it wasn't you, but somebody was. And I think one of the purposes of this hearing is to find out who was targeting conservative groups. Otherwise, you can't explain the fact that you had all these conservative, whether it was Patriot or Tea Party or 912 in their name, selected for extra scrutiny. You had no evidence that there were groups with progressive or names like that were similarly targeted. I mean, I think it's just to put this issue to rest. There's political targeting here. I don't think there's any way you can deny that. I'm interested in knowing, Mr. Miller and Mr. Schulman, if either of you were aware that Ms. Lerner was going to plant that question and try and get ahead of the news cycle by disclosing this prior to the release of the IG report.
I think I mentioned that I did know, yes.
Okay, and were there any discussions? The reporting is that the White House was aware, the White House counsel's office was aware on April 24th of this information. Were there any discussions with the White House about Ms. Lerner's intention to drop this bomb at the ABA conference?
I had no conversations with the White House, sir.
Are you aware of anybody else that did?
I am not aware of that.
There's also been reporting that Deputy Secretary Neil Wolin and Treasury General Counsel were made aware of the IRS or the IG report looking into the targeting of groups last June. Did you have any discussions with Treasury around that time?
That's a question to me, sir?
You or Mr. Schulman? I guess you'd probably be the...
I was deputy at that point, but no, I did not have any conversations at that time.
Mr. Schulman?
I don't remember having any conversations with the Treasury Department.
Okay, so there are no discussions. Are you aware of anybody had discussions with the Treasury Department? The Treasury Department became aware of this information way back last June. None of that was, there were no discussions between the IRS and the Treasury that you're aware of.
Let me clarify. I think everybody knew that it was very difficult to administer the C4 laws. And so I don't have any memory of it, but there very well could have been conversations about policy, the policy matters that members of this committee have talked about. Should the primary purpose test be changed? At least standing for me, there were no conversations that I had with the Treasury Department about the matters in the report relating to inappropriate criteria, all the things that were in the news.
And that's the answer that I was giving, sir, just to be clear.
Okay. Now, Mr. Schulman, you testified in front of the House in March of last year that there was no targeting. You became aware of that in May. Don't you think that you should have had an obligation to clarify or to correct that statement that you made in front of the House committee?
In the spring, when I found out about a list that was being used to help place these applications into the determinations unit, what I knew was there was a list. I did know that Tea Party was on it. I didn't know what else was on the list. I had a partial set of facts, and I knew that the Inspector General was going to be looking into it, and I knew that it was being stopped. And sitting there then, sitting here today, I think I made the right decision, which is to let the Inspector General get to the bottom of it chase down all the facts and then make his findings public.
Let me ask if I could, Mr. George, you mentioned earlier that disclosure of confidential information would be a violation of law.
It is, but whether it is administrative or criminal is the issue. But yes, it could be a violation of the law, specifically Title 26, Section 6103, and or the Restructuring and Reform Act of 1998.
And so the reporting about the giving of this information to ProPublica, release of confidential information, it could very well be a violation of law.
It could be. It could have been, rather, I should say.
And let me just ask all of you, because there was a statement made over the weekend by somebody from the White House that the law would be irrelevant. Do you believe that the law is irrelevant, or is it relevant to this?
I believe the law is always relevant, sir.
Right. Gentlemen? Well, there was a statement made over the weekend that whether the laws were broken was irrelevant. I'm just asking, do you believe that the laws are relevant in this case?
I mean, I guess I would agree with
I think the
Inspector General that people should not break the law.
The answer would be yes. Well, Mr. Chairman, I just think there are a couple issues here. One is the targeting issue, and clearly that has, to me, a lot of political overtones. The other one is if there's information that was disclosed, that would be a violation of law. It's a very serious matter. But I think the American people believe that this is a very serious matter for both those reasons. They believe that the laws ought to be followed, and I think they also believe that they ought to have an IRS that competently conducts its business in an objective, fair, and transparent way. And those are all things that are missing in the equation. And so I hope that we continue to get more facts out about this and that the corrective actions are taken. Thank you, Mr. Chairman.
Senator Burr. Mr. Shulman, who briefed you?
Who briefed me on what, Senator?
Who briefed you on the investigation?
On the investigation?
Yes, sir.
The first I heard, to the best of my recollection of the investigation, was Mr. Miller telling me that there was the existence of the BOLO list, and it was something that the Inspector General was going to look into.
Mr. George, did you brief Mr. Miller, or did any of your investigative team brief Mr. Miller in May of 2012?
It was on May 30th, Senator, 2012, where at a monthly briefing, which we regularly hold with both the commissioner and his chief deputies, that we first raised this as an issue. Obviously, it was at the outset of the investigation.
Now, Mr. Miller says he's not aware of the practice that was going on in the EO. Did you brief him on the scope of the investigation?
I don't believe we went into the detail which may have laid out the scope, Senator, but we certainly alerted them to the fact that we were conducting this audit. I want to make sure I'm clear. I may have misused the word investigation. It was an audit that we were engaging in.
Now, Neil Wolin, as my colleague just pointed out, Deputy Secretary of the Treasury, was briefed in June of 2012. I've just heard two people at the table say they didn't brief him. Mr. George, did you brief, or did part of your investigative team brief Neil Wolin, the Deputy Secretary of Treasury?
Senator, I personally, again, brought to Deputy Secretary Wolin's attention the fact that we were engaging in this audit. And
did that briefing cover the details of the scope of your investigation?
It did not, sir. It was other than to describe the nature of the audit, and that was the extent of it, because there were other matters that we were discussing.
Now, Mr. George, your investigation states that the council was briefed in August of 2011 of the practice at the EO. Was that the IRS council, or was it the Treasury General Counsel?
Actually, sir, it was in June 4th of 2012. I, again, in terms of a regular setting that I have with meeting, I should say, that I have with the General Counsel of the Department of the Treasury.
Now, I know you're talking about your briefing.
Yes.
I'm talking about a reference in your report that the council was briefed by somebody. I take for granted it was somebody within the EO. This was an exchange on the practice that was going on, that the council at the IRS was knowledgeable in 2011. Am I correct?
Sir, it was just pointed out to me that attorneys within the Office of Chief Counsel within the IRS were briefed on.
So the chief counsel of the IRS understood what the practice was that was going on within the EO of these applications, correct?
I was not at that set briefing, sir, but I don't know the extent to which they received information.
Well, here again, this was before your investigation started, but your investigation concluded that the general counsel of the IRS knew of the practices. They had been discussed within the attorneys of the Internal Revenue Service.
It's the Office of Chief Counsel, and that they were provided a briefing.
So is it normal for the chief counsel's office of an agency not to have any conversations with the commissioner or the deputy?
I have no idea of the practices.
Now, let me just turn to both of you. Mr. Miller, you said, are you testifying that the IRS counsel never talked to you about this?
No, sir. I haven't been asked that question, and I don't. If we could step back for a moment, sir. And I think, and I don't know this for a fact, but I think that the timeline that you're referring to when it talks about chief counsel, it's talking about the office of chief counsel, not necessarily the chief counsel. And that could have been anyone in that chain.
So you've got attorneys that are involved in a discussion about the practice that the EO is conducting on how they process applications, C4 applications, and that would not have been something that was raised to the level of commissioner?
Well, let me start by saying I didn't know that until I read the report. So, and I don't know anything about that meeting, sir. That's something that you guys should take a look at.
Mr. Schulman, are you testifying today that the council never discussed this matter with you?
I mean, if you're asking the question, did anyone from the chief counsel's office come and tell me about meetings they were having with the exempt organization function? I have no memory of anyone doing that.
Mr. Chairman, let me suggest that we need to get the chief counsel